In the realm of business and legal agreements, contracts serve as the backbone of transactions, outlining the rights and responsibilities of each party involved. However, what happens when one party fails to uphold their end of the bargain? This is where the concept of breach of contract comes into play. What is breach of contract? Breach of contract occurs when one party to a contract fails to fulfill their obligations as specified in the agreement. This failure can take various forms, including failing to deliver goods or services as promised, not paying the agreed-upon amount, or violating any other terms outlined in the contract. Types of breach. There are generally 3 types of breaches of contract. 1. Material breach. This occurs when one party's failure to perform their obligations under the contract is significant enough to undermine the entire purpose of the agreement. In such cases, the non-breaching party may be entitled to seek damages for losses incurred as a result of the breach. 2. Minor breach. Also known as a partial breach, this occurs when a party fails to fulfill a relatively minor aspect of their obligations under the contract. While the overall purpose of the contract may still be achieved, the non-breaching party may be entitled to seek damages for any losses resulting from the breach. 3. Anticipatory breach. This occurs when one party clearly indicates, either through words or actions, that they do not intend to fulfill their obligations under the contract. In such cases, the non-breaching party may be entitled to terminate the contract and seek damages for any losses suffered. Legal remedies for breach of contract. When a breach of contract occurs, the non-breaching party may pursue various legal remedies to address the situation. Some common remedies include damages. The non-breaching party may seek monetary compensation for any losses suffered as a result of the breach. These damages can include compensatory damages to cover direct losses, as well as consequential damages for any foreseeable indirect losses. Specific performance. In cases where monetary damages are inadequate to remedy the breach, the non-breaching party may seek specific performance, whereby the breaching party is compelled by the court to fulfill their obligations under the contract. Rescission. In certain circumstances, the non-breaching party may seek to rescind or cancel the contract altogether, restoring both parties to their pre-contractual positions. Breach of contract is a serious legal matter that can have significant consequences for all parties involved. Whether you are a business owner, contractor, or individual entering into a contractual agreement, understanding your rights and remedies in the event of a breach is essential. By familiarizing yourself with the basics of breach of contract, you can better protect your interests and navigate potential disputes with confidence.